front names. One of the earliest evolutions in the progress of human nature from savagery to civilization is marked when one reaches that point of the existence of individuality when the use of a name is an obvious necessity. This necessity of course goes back to the remotest period of which human law as opposed to natural law has knowledge. But for the present purpose there is not the smallest necessity to touch upon the matter at that stage. Form names, or what we now term Christian names, the earlier form of the term is christened names, of course, antedate surnames, personal or hereditary, by many centuries, and the Christian Church in its all-embracing practices of appropriation of authority, and in its particular practice of grafting religious ceremony of its own upon occasions of ceremonial which it found in existence, quickly absorbed within its control and authority over Christian names. There is no specific statutory basis for such authority, which must be implied, nor is there the smallest expressed legislative declaration thereof, but undoubtedly the common law of this country does recognize the existence of ecclesiastical law, and save in so far as it has been specifically abrogated, or is in admitted conflict with the common law, and therefore invalid, ecclesiastical law unquestionably retains a certain force and authority which cannot be ignored. More particularly is this the case where ecclesiastical law fills an obvious hiatus in the common law, and does not conflict therewith, which was undoubtedly the case in this country when the law of the Church had universal application, and nonconformity neither existed in fact nor was recognized by the common law. At a period when benefit of clergy was a part of the law of the realm, defeating in a most notable particular the operation of the ordinary common law, it is quite idle to question the effective operation of ecclesiastical procedure, although even as ecclesiastical law no enactment or specific authority can be referred to on the subject of names. The common law will, of course, recognize and enforce custom on proof made of that custom, so that there can be no doubt of the effect in law of a custom so widespread and universal as the giving of names in baptism. The common law unquestionably recognizes this, for though it does not forbid it, it neither provides for nor recognizes any other method of acquiring a Christian name, and it is a point which should not be overlooked that it recognizes the inviolable character of that religious ceremony, and its unalterable effect in conferring a Christian name, because it provides neither through the exercise of the king's prerogative nor by any other operation of law for, nor does it even contemplate the possibility of, a change of Christian name. There is no way known to the law by which a man or woman can change a name which has been given in baptism. Of course an act of parliament can do anything in this country, and, in consequence, any change in the Christian name acquired by baptism must be made by act of parliament. Where baptism does not take place, the Christian name, though selected and given by the parents, is on a different footing. Whatever force it may acquire, and one would hesitate to say definitely that it has any force at all, is derived only from repute. With the repeal of the compulsory authority of the law ecclesiastic, by the statutory recognition of nonconformity, comes the first great breach in the continuity of custom. The custom and its legal validity, however, remain for those who incline to conform to it. But for those who decline such conformity, what law or custom can be said to take or have taken its place? Frankly, there is none. Nonconformists point to the provisions and procedure of the Act for the registration of births, but such a supposed custom is obviously a fallacy. The Act is one for the registration of the fact of birth, and of that only. The insertion of the name of a child is a mere matter of convenience, and a desirability for purposes of identification. Whilst the Act distinctly provides that the fact of a birth must be registered, it is perfectly possible for the child to be registered without a name. The name may be subsequently added to the register, but the provisions relating to the name are purely permissive, and for all that Act, or any other act or any law or custom, provides to the contrary, any person may live or die carefully refraining from acquiring any Christian name at all. There are scores of cases where a child dies without a name. So that, obviously, where a law is silent as to the name, it cannot be invoked as a statutory authority to stereotype or validly confer a name. The sum total of the effect of the registration of a name concurrently with the registration of birth, is merely an authoritative and notable record of the commencement of repute, which, however, must continue uninterruptedly to crystallize into such repute as the law will take cognizance of. Unquestionably, if nothing subversive of or contrary to that repute occurs, then the registered name has acquired a certain force, and stands until it is upset by an overt act or by a repute to the contrary. The position may be put thus, that a baptismal name is a name conferred in a method that the common law has sanctioned for centuries, and which was formerly the only way in which a name could be conferred, that this method was one which the common law not only recognized, but made compulsory by statute, under the statutory authority placed upon the services contained in the prayer book, that nothing has occurred to alter the binding statutory legality of the prescribed service of baptism upon all conforming members of the Church of England, and that the fact that conformity has since been made permissive and not compulsory does not remove any part of the legal status of a name acquired in baptism by those who elect to conform. A baptismal name, therefore, is of higher authority than a name based upon repute only. For while repute may lapse or may be destroyed and superseded by contrary repute, baptism cannot. But repute can be superseded by baptism. If, therefore, a child has been registered in one Christian name and baptized in another, the baptismal name, which short of an Act of Parliament is unchangeable, is its true and unalterable name, and priority of baptism or of registration has no weight one way or the other. An entire change of name at a time of adult baptism is a lawful and irrevocable conferring of a name, absolutely operative as a bar to prior repute. The Church in relation to baptism permits this rite to be performed by any person, and there is no set form of words essential beyond the mere declaration of some person, who, sprinkling the child with water, states that he or she baptizes the child in the name of the Father, Son and Holy Ghost, so that practically within these very wide limits any professed ceremonial of baptism, with or without witnesses, in church, chapel or private house, is a valid baptism even by the law ecclesiastic, and consequently, a lawful and effective conferring of a name. And though the Church asks after informal baptism for the subsequent ceremony of the public reception of the child into the Church, there is nothing in the Church service to question the absolute and abiding validity of the informal ceremony. Where nothing which the Church will recognize as baptism takes place, there is no conferring of a name which the law has recognized, for the common law cannot make into baptism a proceeding which the Church declines to recognize as such. And though the common law has recognized and made of authority that ceremony of the Church, it has provided nothing as a substitute where there has been no baptism. There does not appear to be any civil penalty enforceable upon a clergyman for not making a proper entry in his church registers after the ceremony has taken place. Therefore there is no guarantee that the name given at the ceremony will be properly registered. Under these circumstances, it is desirable that the names should be written and handed to the clergyman before the ceremony, so that the child may be called by the right name, and that there may be no discrepancies in spelling when the written evidence of the fact of baptism and of the name given in that baptism is being created in the ecclesiastical register. At the same time a mandamus will lie under the acts relating to the making of parish registers to compel any clergyman to make an entry in his register of any baptism which takes place. There exists no machinery for making alterations in a church register. There are many cases in which this has been done, however, though whether done properly or not is open to discussion. Entries registering baptisms, and c. made at a date long after the ceremonies have been performed are by no means uncommon in church registers, and they are found interlined or out of their order of date. Such entries are always open to grave suspicion, consequently it is desirable that where the necessity for them arises, full explanation thereof should be inserted and signed by the clergyman. The fact that, short of an Act of Parliament, the law knows no way in which a Christian name can be changed, however, does not seem to deter the perennial attempt on the part of those who object to the name bestowed upon them in baptism to make the change they desire. Therefore two facts should be borne in mind. First, as will be subsequently explained at greater length in relation to changes of surnames, that, provided always that no question of deception or fraud enters into the matter, an act done in any name holds for good or bad equally with an act done in a genuine name. There is a possible exception to this generalization in the Moneylenders Act. The second point to be remembered is that a change in any name leads to doubt of identity, so that if any change in a Christian or front name is made, lasting evidence of the facts of the change should be created at the time of the change. This can be done by an advertisement in a newspaper, or by a deed poll enrolled in the High Court. A copy of a newspaper gets lost, and back numbers of a paper are not always easy to procure, even when the actual date of the appearance of the advertisement is known. The Times is unquestionably the best paper to make use of, because an index to this is compiled and published. A deed poll, however, is better. Such a document does not run the same risk of destruction as a newspaper, and, being formally enrolled, the evidence is perpetuated beyond loss for all time to come. But such a change is not a legal change, and neither advertisement nor deed poll can make it legal. The change is no more than an unauthorized alias, and the advertisement and the deed poll do no more than establish unquestionably the fact of the identity of the person described at the different periods under his genuine name or under his alias. But there is one other custom which probably has equal binding effect with baptism, and that is the Jewish ceremony of circumcision, and the concurrent naming of the child. The Jewish ceremony is on a different footing altogether from nonconformist procedure. There is not the very smallest statutory authority for nonconformity. In the eye of the law, nonconformity has no positive existence, at any rate as far as its ceremonial is concerned. It is purely negative, a statutory relief from the compulsion of ecclesiasticism and the law ecclesiastic. Nonconformity cannot of itself create a ceremonial of which the law can be cognizable. The law has created no ceremonial for nonconformity, except the statutory recognition which exists of its ceremonials of marriage. The important point is that nonconformity is subsequent alike to the Catholic Church and to the established Church. The Jewish religion antedates them both. The Jewish ceremonial is an integral part of Judaism. It is a custom so fixed and determinate that the law must recognize it as a custom binding in and upon Jewry, and upon proof made, must declare and pronounce for that custom. For the Jewish religion, and for the specific practice of Judaism in this country, there is specific and precise statutory authority, quite apart from the general statutory reliefs upon which nonconformity at large is based. That specific permission and authority must be held to sanction the special customs and ceremonial of Jewry, and, in particular, the ceremony of circumcision and naming. There can be little doubt, therefore, that a Jewish forename is upon the equivalent basis to a baptismal name. No doubt similar remarks hold good concerning other ancient non-Christian religions within the British Empire, which either by express enactment, or by our recognized and undoubted constitutional custom, are permitted to retain and practice their ceremonial as theretofore accustomed. As a matter of practice, the Roman Catholic religion requires at least one of the baptismal names to be that of some saint included in the calendar. The established Church of England neither in practice nor in law asserts any such position. Some clergymen seek to veto the name chosen by the parents, but the ordinary citizen has this remedy against the clergyman of the established Church, which does not lie against nonconformist ministers. A clergyman of the Church of England is, in his ceremonial duties, subject to the law of the land. He is bound to perform the ceremony of baptism when so required by a parishioner, and the law will compel him to do so by mandamus. And as both the law ecclesiastic and universal custom assign the choice of a child's name to its parents or godparents, a clergyman is bound to baptize a child in whatever name the godparents declare to him at the proper time in a baptismal ceremony. But it should be borne in mind that baptism is a Christian ceremony, and that no Christian minister can be compelled to perform the Christian ceremony of baptism and therein confer a name in open and direct antagonism with Christianity. A case some years ago obtained much newspaper notoriety. It did not, we believe, reach any court of law, in which a clergyman declined, and rightly declined, to baptize a child by the name of Beelzebub. The privilege of signing the surname or peerage designation only, or rather, of omitting the Christian name in the signature, is in this country a privilege rigidly confined to peers, who merely sign the designation of their peerage. Peeresses in their own right sign in the same manner, without the use of a Christian name. Peeresses by marriage sign their Christian names, or initials, followed by their peerage designation. Those who are peeresses by marriage and also peeresses in their own right have obviously the choice of either or both these two methods. The instances are of course rare, but in the cases of the late Duchess of Sutherland, the Countess of Yarborough, and the Countess of Powys, the signature has been the initial, or the Christian name, and the higher peerage, by marriage, designation followed by the lower peerage, by inheritance, designation alone. There is no statutory or common law basis in England for this privileged custom of signing by the title only and omitting the Christian name, and the custom dates little, if anything, earlier than the Stuart period, nor is it easy to account for its origin. There is, however, express statutory authority in Scotland, where it is illegal for anyone being neither peer nor bishop to sign without prefixing the christened name or its initial letter, but express permission is given by the Act, 1672, that anyone may adject to his name the designation of his lands. Cases have occurred in which, in compliance with the terms of a will or settlement, a peer has received a royal license to assume an additional surname. The 4th Duke of Portland, after 1795, when he received a royal license to assume that name, signed Scott Portland. A royal license was issued in 1789 to Lord Eliot of Street Germans to assume the name of Cras in addition to Eliot, with power to subscribe the name of Cras before all titles of honour. No doubt these are exceptional cases, depending upon express terms of settlement or bequest, but the Declaration, 1906, relieving Lady Dunsany from the necessity of subscribing an assumed surname in conjunction with a peerage title will no doubt form a sufficient precedent for the future granting of such relief in a similar case. The royal family of this country, as do the members of all other sovereign houses, sign by their Christian names only, and do not use the peerage designations they may possess. The reason is simple. In the early days, when both surnames and customs were in the making, kings and their families neither needed nor used surnames. Contrary to popular notions, Plantagenet was not a surname, nor even for junior members of the royal house is any record to be found of contemporary use of that designation, with one, and that a late, exception. Tudor may have been, Stuart certainly was a surname. Gulf was not, nor has his present Majesty any surname at all. To this extent is the absence of a surname carried, that HRH the Princess Royal does not sign as a peeress Louise Fife, but Louise, Duchess of Fife.